The Honourable David Parker.
Mr Chairman, can I just follow that through a bit with the Minister, because Clause 57(1) says that a declaratory order can only be made by a judge when he's satisfied, or she is satisfied, that the activity is reasonable and lawful. The Hamid decision said that trespassory search and surveillance that did not have express legislative authority is unlawful. That's the effect of the Hamid decision. So this can never work in respect of a method of search and surveillance that involves trespass on private property, be it a car or a house, in the way which was being envisaged. This whole thing's turned around because one of the ways in which this was justified at Select Committee was that where there was no express authorisation of a surveillance technique that required it to be warranted, that surveillance technique was, as a consequence of common law decisions, legal because it wasn't required to be warranted. And the Hamid decision said that that proposition was wrong. So when this declaratory order provision was being thought through, it was being seen as a way to protect civil liberties by perhaps encouraging the police to go for some sort of judicial oversight of what was lawful but might be unreasonable if done a certain way, but done another way might be both lawful and reasonable. We now know that in respect of trespassory search and surveillance that is not expressly authorised by legislative authority for the enforcement officer, it is unlawful, and therefore 57(1) can't apply. So I think, Mr Minister, that can never apply except in respect of non-trespassory surveillance, where Hamid says that you can have non-trespassory surveillance that is not expressly authorised, which does not infringe the Bill of Rights. So that's my first point. The second point, to develop the theme that Charles Chevelle was, and I listened to Charles and I thought that that was right, and I'm convinced by that argument that we ought not to have this advisory role for the courts, and he was referring to the effect of a higher court decision on, in practice, the decision that would subsequently be taken by a lower court. But let's just consider the actual case in point. Let's say the evidence was gathered and then was challenged by the accused at trial. Are we saying that the later decision as to whether that evidence ought to be admitted under the judicial discretion to admit illegally obtained evidence which is so serious as to warrant being admitted, despite the fact that it's illegal evidence, and that discretion does exist as law, as we've seen in respect of Tama Iti and others in the Tuhoi case? Are we saying that we are so naive that we think that exercise of discretion at trial will not be influenced by the declaratory order? Well, I think that would be naive to say that. And if it isn't, if it is naive, and if it would influence it, well, that's wrong, because we have an adversarial system where, on an ex parte basis, with just one side, on this case the police, telling the judicial officer what they think without the other side of the case being put on behalf of the accused, who may be innocent. They're an accused, they're not a guilty party, they are merely an accused. That would be wrong. So, Mr Chairman, the Labour Party has prepared an amendment, and we would encourage the Greens and New Zealand First and the ACT Party and others to consider it carefully, to actually expunge these particular provisions from Part 3 so that declaratory orders aren't carried forward. This will cause no great hole in our justice system. There have never been declaratory orders in existence until now. Declaratory orders were not needed in order to preserve the admissibility of the evidence against some of the more, in respect of some of the serious offences alleged in the Tuhoi case. They are illegally obtained search and surveillance evidence which has nonetheless been admitted to court under the discretion that the court has to admit evidence even though it's been illegally obtained. So there are lots of protections of the public out there already. We don't need this one as well to confer additional powers on state agencies to embark on search and surveillance measures. So, Mr Chairman, I would ask you to address this issue as to what's the effect of this in light of Harmid when it's not lawful.
Dr Cam Calder.
I move the question be now put.
I'll call Chris Farfoy.
Thank you very much, Mr Chair, for the call on the Part